Please be seated. The sitting is open. The court meets today pursuant to Article 58 of the statute to deliver its judgment in the case concerning the application of the International Convention for the Suppression of the Financing of Terrorism and of the International Convention on the Elimination of all Forms of Racial Discrimination, Ukraine versus Russian Federation. Vice President Shue, Judges Benuna, Bandari, and Robinson, who duly participated in both the deliberation and the final vote, are, for reasons explained to me, unable to take their seats on the bench today. These proceedings were instituted on 16 January 2017 by the filing in the registry of an application by Ukraine against the Russian Federation with regard to alleged violations by the latter of its obligations under the International Convention for the Suppression of the Financing of Terrorism of 9 December 1999 and the International Convention on the Elimination of all Forms of Racial Discrimination of 21 December 1965. On 12 September 2018, the Russian Federation raised preliminary objections to the jurisdiction of the court and the admissibility of the application. The proceedings on the merits were accordingly suspended. In accordance with the usual practice, I shall not read out the introductory paragraphs of the judgment, which set out the main elements in the procedural history of the case. I shall also omit or summarize some of the other paragraphs of the judgment. I shall begin the reading of the judgment at paragraph 23. The full text will, of course, be available at the close of the sitting. The present proceedings were instituted by Ukraine following the events which occurred in eastern Ukraine and in Crimea from the spring of 2014, on which the parties have different views. However, the case before the court is limited in scope. With regard to the events in eastern Ukraine, the applicant has brought proceedings only under the ICSFT. With regard to the situation in Crimea, Ukraine's claims are based solely upon the CERD or CERD. The court observes that the parties have expressed divergent views as to the subject matter of the dispute brought by Ukraine before it. The court recalls that applications that are submitted to it often present a particular dispute that arises in the context of a broader disagreement between the parties. The fact that a dispute before the court forms part of a complex situation that includes various matters, however important, over which the states concerned hold opposite views, cannot lead the court to decline to resolve that dispute, provided that the parties have recognized its jurisdiction to do so and the conditions for the exercise of such jurisdiction are otherwise met. In the present case, the court notes that Ukraine is not requesting the court to rule on issues concerning the Russian Federation's purported aggression or its alleged unlawful occupation of Ukrainian territory. Nor is the applicant seeking a pronouncement from the court on the status of Crimea or on any violations of rules of international law other than those contained in the ICSFT and the CER. These matters, therefore, do not constitute the subject matter of the dispute before the court. The court observes that Ukraine requests the court to adjudge and declare that the Russian Federation has violated a number of provisions of the ICSFT and CER, that it bears international responsibility for those violations, and that it is required to cease such violations and make reparation for the consequences thereof. The court considers that it follows from the opposing views expressed by the parties in the present case that the dispute consists of two aspects. First, the parties differ as to whether any rights and obligations of the parties under the ICSFT with regard to the prevention and suppression of the financing of terrorism were engaged in the context of events which occurred in eastern Ukraine starting in the spring of 2014, and whether terrorism financing offenses within the meaning of Article 2, Paragraph 1 of the ICSFT were committed. As a result of these differences of views, the parties draw opposite conclusions as to the alleged breaches by the Russian Federation of its obligations under Articles 8, 9, 10, 12, and 18 of the ICSFT, and as to its ensuing international responsibility. Secondly, the parties disagree as to whether the decisions on measures allegedly taken by the Russian Federation against the Crimean Tatar and Ukrainian communities in Crimea constitute acts of racial discrimination, and whether the Russian Federation bears responsibility in that regard for the violation of its obligations under Articles 2, 4, 5, 6, and 7 of CER. In view of the foregoing, the court concludes that the subject matter of the dispute, insofar as its first aspect is concerned, is whether the Russian Federation had the obligation under the ICSFT to take measures and to cooperate in the prevention and suppression of the alleged financing of terrorism in the context of events in eastern Ukraine, and if so, whether the Russian Federation breached such an obligation. The subject matter of the dispute, insofar as its second aspect is concerned, is whether the Russian Federation breached its obligations under CER through discriminatory measures allegedly taken against the Crimean Tatar and Ukrainian communities in Crimea. It is with respect to the claims underlying this subject matter of the dispute between the parties that the court has to determine its jurisdiction. To establish such jurisdiction in the present case, Ukraine invokes Article 24, Paragraph 1 of the ICSFT and Article 22 of CER, conventions to which both Ukraine and the Russian Federation are parties. The Russian Federation contests the court's jurisdiction to entertain the dispute on the basis of each of the two instruments invoked by Ukraine. In this regard, the Russian Federation argues that the dispute is not one which the court has jurisdiction ratione materiae to entertain, either under Article 24, paragraph 1 of the ICSFT, or under Article 22 of CERN, and that the procedural preconditions set out in these provisions were not met by Ukraine before it seized the court. The respondent further contends that Ukraine's claims under CERN are inadmissible, since in its view, available local remedies had not been exhausted before Ukraine filed this application with the court. The court will first address the preliminary objection raised by the Russian Federation to its jurisdiction on the basis of the ICSFT. In particular, the court will examine first whether it has jurisdiction ratione materiae under Article 24, paragraph 1 of the ICSFT, and whether the procedural preconditions set forth in that provision have been met. In this context, the court recalls that it is jurisdiction ratione materiae over the dispute under Article 24, paragraph 1 of the ICSFT covers, and I quote, any dispute between two or more states parties concerning the interpretation or application of this convention, end of quote. The court has therefore to determine whether the dispute between the parties is one that concerns the interpretation or the application of the ICSFT, and whether it has jurisdiction ratione materiae under Article 24, paragraph 1 of this convention. For the court, in order to determine its jurisdiction ratione materiae under a compromissory clause concerning disputes relating to the interpretation or application of a treaty, it is necessary to ascertain whether the acts of which the applicant complains fall within the provisions of the treaty containing the compromissory clause. This may require the interpretation of the provisions that define the scope of the treaty. In the present case, the ICSFT has to be interpreted according to the rules contained in Articles 31 to 33 of the Vienna Convention on the Law of Treaties of 23 May 1969, hereinafter referred to as the Vienna Convention, to which both Ukraine and the Russian Federation are parties as of 1986. It is the view of the court that at the present stage of the proceedings, an examination of the alleged wrongful acts or of the plausibility of the claims is not generally warranted. The court is tasked, as reflected in Article 79 of the Rules of Court of 14 April 1978, as amended on 1 February 2001, is to consider the questions of law and fact that are relevant to the objection to its jurisdiction. The court observes that the ICSFT imposes obligations on states parties with respect to offenses committed by a person when, and I quote, that person by any means, directly or indirectly, unlawfully and willfully, provides or collects funds with the intention that they should be used or in the knowledge that they are to be used in full or in part in order to carry out, end of quote, acts of terrorism as described in Article 2, paragraph 1A and B. As stated in the preamble of the Convention, the purpose of the Convention is to adopt effective measures for the prevention of the financing of terrorism as well as for its suppression through the prosecution and punishment of its perpetrators. The ICSFT addresses offenses committed by individuals. In particular, Article 4 requires each state party to the Convention to establish the offenses set forth in Article 2 as criminal offenses under its domestic law and to make those offenses punishable by appropriate penalties. The financing by a state of acts of terrorism is not addressed by the ICSFT. It lies outside the scope of the Convention. This is confirmed by the preparatory work of the Convention, which indicates that proposals to include financing by states of acts of terrorism were put forward but were not adopted. As was recalled in the report of the ad hoc committee established by the General Assembly, which contributed to the drafting of the ICSFT, some delegations even proposed to exclude all matters of state responsibility from the scope of the Convention. However, it has never been contested that if a state commits a breach of its obligations under the ICSFT, its responsibility would be engaged. The conclusion that the financing by a state of acts of terrorism lies outside the scope of the ICSFT does not mean that it is lawful under international law. The Court recalls that in Resolution 1373 of 2001, the United Nations Security Council, acting under Chapter 7 of the Charter, decided that all states shall, and I quote, refrain from providing any form of support, active or passive, to entities or persons involved in terrorist acts, end of quote. When defining the perpetrators of offenses of financing acts of terrorism, Article 2 of the ICSFT refers to any person. According to its ordinary meaning, this term covers individuals comprehensively. The Convention contains no exclusion of any category of persons. It applies both to persons who are acting in a private capacity and to those who are state agents. As the Court already noted, state financing of acts of terrorism is outside the scope of the ICSFT. Therefore, the commission by a state official of an offense described in Article 2 does not in itself engage the responsibility of the state concerned under the Convention. However, all states parties to the ICSFT are under an obligation to take appropriate measures and to cooperate in the prevention and suppression of offenses of financing acts of terrorism committed by whichever person. Should a state breach such an obligation, its responsibility under the Convention would arise. The Court further observes that, as the title of the ICSFT indicates, The Convention specifically concerns the support given to acts of terrorism by financing them. Article 2, paragraph 1 refers to the provision or collection of funds. This term, which is defined in Article 1, paragraph 1, covers many kinds of financial instruments and includes also other assets. Since no specific objection to the court's jurisdiction was made by the Russian Federation with regard to the scope of the term funds, and in particular to the reference in Ukraine's submissions to the provision of weapons, this issue relating to the scope of the ICSFT need not be addressed at the present stage of the proceedings. However, the interpretation of the definition of funds could be relevant as appropriate at the stage of an examination of the merits, should the case proceed to the merits. Finally, the court notes that an element of an offense under Article 2, paragraph 1 of the ICSFT is that the person concerned has provided funds, and I quote, with the intention that they should be used or in the knowledge that they are to be used to commit an act of terrorism, end of quote. The existence of the requisite intention or knowledge raises complex issues of law and especially of fact that divide the parties and are properly a matter for the merits. The same may be said of the question whether a specific act falls within the meaning of Article 2, paragraph 1A or B. This question is largely of a factual nature and is properly a matter for the merits of the case. Within the framework of the ICSFT, questions concerning the existence of the requisite mental elements do not affect the scope of the Convention and therefore are not relevant to the court's jurisdiction ratione materia. They are questions that fall to be decided at the merits stage. In light of the above, the court concludes that the objection raised by the Russian Federation to its jurisdiction ratione materia under the ICSFT cannot be upheld. The court next examines whether the procedural preconditions set forth in Article 24, paragraph 1 of the ICFT have been fulfilled. In this context, the court has to examine whether the dispute between the parties could not be settled through negotiation within a reasonable time, and if so, whether the parties were unable to agree on the organization of an arbitration within 6 months from the date of the request for arbitration. With regard to settlement through negotiations, it is the court's view that Article 24, paragraph 1 of the ICSFT requires, as a first procedural precondition to the court's jurisdiction, that a state makes a genuine attempt to settle through negotiation the dispute in question with the other state concerned. According to the same provision, the precondition of negotiation is met when the dispute, and I quote, cannot be settled through negotiation within a reasonable time, end of quote. As was observed in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination, Georgia versus Russian Federation, the subject matter of the negotiations must relate to the subject matter of the dispute, which in turn must concern the substantive obligations contained in the treaty in question. The court recalls in this connection that on 28 July 2014, Ukraine wrote a note verbal to the Russian Federation proposing inter alia to conduct negotiations on the issue of interpretation and application of the ICSFT. On 15 August 2014, the Russian Federation informed Ukraine of its readiness to conduct negotiations on the issue of interpretation and application of the ICSFT. While exchanges of notes and meetings between the parties did not always focus on the interpretation or application of the ICSFT, negotiations over Ukraine's claims relating to this convention constituted a substantial part of it. Moreover, 4 meetings were held in Minsk, the last one on 17 March 2016. Little progress was, however, made by the parties during their negotiations. The court therefore concludes that the dispute could not be settled through negotiation in what has to be regarded as a reasonable time, and that the first precondition is accordingly met. The court now turns to the examination of whether the parties were unable to agree on the organization of an arbitration. The court recalls in this connection that nearly 2 years after the start of negotiations between the parties over the dispute, Ukraine sent on 19 April 2016 a note verbal in which it stated that those negotiations had failed, and that, I quote, pursuant to Article 24, Paragraph 1 of the Financing Terrorism Convention, it requested the Russian Federation to submit the dispute to arbitration under terms to be agreed by mutual consent, end of quote. Negotiations concerning the organization of the arbitration were subsequently held until a period of 6 months expired. During these negotiations, Ukraine also suggested to refer the dispute to a procedure other than arbitration, namely the submission of the dispute to a chamber of the court. In any event, the parties were unable to agree on the organization of the arbitration during the requisite period. The second precondition, stated in Article 24, Paragraph 1 of the ICSFT, must thus be regarded as fulfilled. The court therefore considers that the procedural preconditions set forth in Article 24, Paragraph 1 of the ICSFT were met. The court thus concludes that it has jurisdiction to entertain the claims made pursuant to that provision. The court now turns, in this part of its judgment, to the Russian Federation's preliminary objections to its jurisdiction and to the admissibility of Ukraine's claims under CERT. As stated earlier, the Russian Federation argues that the court lacks jurisdiction ratione materiae under CERT, and that the procedural preconditions to the court's jurisdiction set out in Article 22 of the Convention are not met. It also argues that Ukraine's application with regard to claims under CERT is inadmissible because local remedies had not been exhausted before the dispute was referred to the court. The court deals with each of these objections in turn. In order to determine whether it has jurisdiction ratione materiae under CERT, the court does not need to satisfy itself that the measures of which Ukraine complains actually constitute racial discrimination within the meaning of Article 1, Paragraph 1 of CERT, nor does the court need to establish whether and if so, to what extent certain acts may be covered by Article 1, Paragraph 2 and 3 of CERD. Both determinations concern issues of fact, largely depending on evidence regarding the purpose or effect of the measures alleged by Ukraine, and are thus properly a matter for the merits should the case proceed to that stage. At the current stage of the proceedings, the court only needs to ascertain whether the measures of which Ukraine complains fall within the provisions of the Convention. In this respect, the court notes that both parties agree that the Crimean Tatars and ethnic Ukrainians in Crimea constitute ethnic groups protected under CERD. Moreover, Articles 2, 4, 5, 6, and 7 of the Convention set out specific obligations in relation to the treatment of individuals on the basis, and I quote, of race, color, descent, or national or ethnic origin, end of quote. Article 2, Paragraph 1 of CERD contains a general obligation to pursue by all appropriate means a policy of eliminating racial discrimination against persons, groups of persons, or institutions. Article 5 imposes an obligation to prohibit and eliminate racial discrimination and to guarantee the right of everyone to equality before the law, notably in the enjoyment of rights mentioned therein, including political, civil, economic, social, and cultural rights. The court, taking into account the broadly formulated rights and obligations contained in the Convention, including the obligations under Article 2, Paragraph 1, and the non-exhaustive list of rights in Article 5, considers that the measures of which Ukraine complains are capable of having an adverse effect on the enjoyment of certain rights protected under CERD. These measures thus fall within the provisions of the Convention. Consequently, the court concludes that the claims of Ukraine fall within the provisions of CERD. Having established that the claims of Ukraine fall within the scope of CERD, the court turns to the examination of the procedural preconditions under Article 22 of the Convention. Pursuant to Article 22 of CERD, the court has jurisdiction to decide a dispute brought under the Convention, provided that such a dispute is, I quote, not settled by negotiation or by the procedures expressly provided for in this Convention, end of quote. In the Georgia versus Russian Federation case, the court found that in their ordinary meaning, the terms of Article 22 of CERD establish preconditions to be fulfilled before the session of the court. In that case, the court did not determine whether the preconditions set out in Article 22 of CERD are alternative or cumulative. In the present case, the parties expressed divergent views on the meaning of the word "or" in the phrase "not settled by negotiation or by the procedures expressly provided for in this Convention." The court noticed that the conjunction "or" appearing between negotiation and the phrase "procedures expressly provided for in this Convention" is part of a clause which is introduced by the word "not" and thus formulated in the negative. While the conjunction or should generally be interpreted disjunctively, if it appears as part of an affirmative clause, the same view cannot necessarily be taken when the conjunction is part of a negative clause. Article 22 is an example of the latter. It follows that in the relevant part of Article 22 of SER, the conjunction or may have either disjunctive or conjunctive meaning. The Court is therefore of the view that Article 22 of SER must also be interpreted in its context. Article 22 refers to two preconditions, namely negotiation and the procedure before the third committee, governed by Articles 11 to 13 of the Convention. Article 11, paragraph 1 of SER envisages that if a state party considers that another state party is not giving effect to the provisions of the Convention, it may bring the matter to the attention of the third committee. The third committee will then transmit the communication to the state party concerned, which within 3 months shall submit to the committee written explanations or statements clarifying the matter and the remedy, if any, that may have been taken. Under Article 11, paragraph 2, a state has the right to refer the matter back to the third committee through a second communication if the matter is not adjusted to the satisfaction of both parties, either by bilateral negotiations or by any other procedure open to them within 6 months after the receipt by the receiving state of the initial communication. Pursuant to Article 12, paragraph 1a of SER, after the third committee has obtained the necessary information, its chairperson shall appoint an ad hoc conciliation commission, the good offices of which shall be made available to the states concerned, with a view to an amicable solution of the matter. Article 13, paragraph 1 provides that when the Commission has fully considered the matter, it shall submit to the chairperson of the third committee a report containing such recommendations as it may think proper for the amicable solution of the dispute. Pursuant to Article 13, paragraph 2, the states concerned, within 3 months of receiving such recommendations from the chairperson of the committee, shall inform the chairperson as to whether or not they accepted the recommendations contained in the report of the Commission. The references to the, and I quote, amicable solution, end of quote, of the dispute, and to the state's communication of acceptance of the Conciliation Commission's recommendations indicate, in the Court's view, that the objective of the third committee procedure is for the states concerned to reach an agreed settlement of their dispute. The Court therefore considers that negotiation and the procedures expressly provided for in the Convention are two means to achieve the same objective, namely to settle a dispute by agreement. Both negotiation and the third committee procedure rest on the states parties' willingness to seek an agreed settlement of their dispute. It follows that should negotiation and the third committee procedure be considered cumulative, states would have to try to negotiate an agreed solution to their dispute, and after negotiations had not been successful, take the matter before the third committee for further negotiation again in order to reach an agreed solution. The court considers that the context of Article 22 of CERD does not support this interpretation. In the view of the court, the context of Article 22 rather indicates that it would not be reasonable to require states parties which have already failed to reach an agreed settlement through negotiations to engage in an additional set of negotiations in accordance with the modalities set out in Articles 11 to 13 of CERD. The court further considers that Article 22 of CERD must be interpreted in light of the object and purpose of the Convention. Article 2, paragraph 1 of CERD provides that states parties to CERD undertake to eliminate racial discrimination without delay. Articles 4 and 7 provide that states parties undertake to eradicate incitement to racial discrimination and to combat prejudices leading to racial discrimination by adopting immediate and positive measures and immediate and effective measures, respectively. The preamble to CERD further emphasizes the state's resolve to adopt all measures for eliminating racial discrimination speedily. The court considers that these provisions show the states parties' aim to eradicate all forms of racial discrimination effectively and promptly. In the court's view, the achievement of such aims could be rendered more difficult if the procedural preconditions under Article 22 were cumulative. The court notes that both parties rely on the travaux préparatoires of CERD in support of their respective arguments concerning the alternative or cumulative character of the procedural preconditions under Article 22 of the Convention. Since the alternative character of the procedural preconditions is sufficiently clear from an interpretation of the ordinary meaning of the terms of Article 22 in their context and in light of the object and purpose of the Convention, the Court is of the view that there is no need for it to examine the travaux préparatoires of CERD. The Court concludes that Article 22 of CERD imposes alternative preconditions to the Court's jurisdiction. Since the dispute between the parties was not referred to the CERD committee, the Court will only examine whether the parties attempted to negotiate a settlement to their dispute. In this connection, the Court recalls that it has already had the opportunity to examine the notion of negotiation under Article 22 of CERD. In its previous jurisprudence, the Court has stated that, and I quote, negotiations are distinct from mere protests or disputations and require, at the very least, a genuine attempt by one of the disputing parties to engage in discussions with the other disputing party with a view to resolving the dispute, end of quote. The Court has further held that the precondition of negotiation is met only when there has been a failure of negotiations or when negotiations have become futile or deadlocked. The Court notes that Ukraine sent its first note verbal to the Russian Federation concerning alleged violations of CERD on 23 September 2014. In that note, Ukraine listed a number of measures which, in its view, the Russian Federation was implementing in violation of the CERD Convention and the rights which such acts were allegedly violating, and went on to state that, and I quote, "The Ukrainian side offers to the Russian side to negotiate the use of CERD, in particular the implementation of international legal liability in accordance with international law," end of quote. On 16 October 2014, the Russian Federation communicated to Ukraine its willingness to hold negotiations on the interpretation and application of CERD. Eventually, after various exchanges regarding the organization of bilateral discussions, the parties held 3 rounds of negotiation in Minsk between April 2015 and December 2016. There are specific references to CERD in the not-verbal exchange between the parties, which also refer to the rights and obligations arising under the Convention. In those notes, Ukraine set out its views concerning the alleged violations of the CERD Convention, and the Russian Federation accordingly had a full opportunity to reply to such allegations. The court is satisfied that the subject matter of such diplomatic exchanges related to the subject matter of the dispute currently before the court. The court observes that the negotiations between the parties lasted for approximately 2 years and included both diplomatic correspondence and face-to-face meetings, which, in the court's view, and despite the lack of success in reaching a negotiated settlement, indicates that a genuine attempt at negotiation was made by Ukraine. Furthermore, the court is of the opinion that during their diplomatic exchanges, the parties' respective positions remained substantially the same. The court thus concludes that the negotiations between the parties had become futile or deadlocked by the time Ukraine filed its application under Article 22 of CERD. Accordingly, the court concludes that the procedural preconditions for it to have jurisdiction under Article 22 of CERD are satisfied in the circumstances of the present case. As a result, the court has jurisdiction to consider the claims of Ukraine under CERD. The court finally turns to the objection raised by the Russian Federation to the admissibility of Ukraine's application with regard to claims under CERD on the ground that Ukraine did not establish that local remedies had been exhausted before it seized the court. The court recalls that local remedies must be previously exhausted as a matter of customary international law in cases in which a state brings a claim on behalf of one or more of its nationals. The court noticed that, according to Ukraine, the Russian Federation has engaged in a sustained campaign of racial discrimination carried out through acts repeated over an appreciable period of time, starting in 2014, against the Crimean Tatar and ethnic Ukrainian communities in Crimea. The court also noticed that the individual instances to which Ukraine refers in its submissions emerge as illustrations of the acts by which the Russian Federation has allegedly engaged in a campaign of racial discrimination. It follows, in the view of the court, that in filing its application under Article 22 of CERD, Ukraine does not adopt the cause of one or more of its nationalists, but challenges on the basis of CERD the alleged pattern of conduct of the Russian Federation with regard to the treatment of the Crimean Tatar and Ukrainian communities in Crimea. In view of the above, the court concludes that the rule of exhaustion of local remedies does not apply in the circumstances of the present case. This conclusion by the court is without prejudice to the question of whether the Russian Federation has actually engaged in the campaign of racial discrimination alleged by Ukraine, thus breaching its obligations under CERD. This is a question which the court will address at the merits stage of the proceeding. The court finds that the Russian Federation's objection to the admissibility of Ukraine's application with regard to claims under CERD must be rejected. It follows from the findings made above that the Russian Federation's objections to the jurisdiction of the court under Article 22 of CERD and to the admissibility of Ukraine's application with regard to CERD must be rejected. Accordingly, the court concludes that it has jurisdiction to entertain the claims made by Ukraine under CERD and that Ukraine's application with regard to those claims is admissible. For these reasons, the court, 1, by 13 votes to 3, rejects the preliminary objection raised by the Russian Federation that the court lacks jurisdiction on the basis of Article 24, paragraph 1 of the International Convention for the Suppression of the Financing of Terrorism. In favor, President Yusuf, Judges Abraham, Benuna, Cansado Trinidad, Donahue, Gaia, Sebutinde, Bandari, Robinson, Crawford, Salam, Iwasawa, Judge Ad hoc, Pokar. Against, Vice President Shue, Judges Tomka, Judge Ad hoc, Skotnikov. 2, by 13 votes to 3, finds that it has jurisdiction on the basis of Article 24, paragraph 1 of the International Convention for the Suppression of the Financing of Terrorism to entertain the claims made by Ukraine under this convention. In favor, President Yusuf, Judges Abraham, Benuna, Cansado Trinidad, Donahue, Gaia, Sebutinde, Bandari, Robinson, Crawford, Salam, Iwasawa, Judge Ad hoc, Pokar. Against, Vice President Shue, Judge Tomka, Judge Ad hoc, Skotnikov. 3, by 15 votes to 1, rejects the preliminary objection raised by the Russian Federation that the court lacks jurisdiction on the basis of Article 22 of the International Convention on the Elimination of All Forms of Racial Discrimination. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado Trinidad, Donahue, Gaia, Sebutinde, Bandari, Robinson, Crawford, Salam, Iwasawa, Judge Ad hoc, Pokar. Against, Judge Ad hoc, Skotnikov. 4, unanimously, rejects the preliminary objection raised by the Russian Federation to the admissibility of the application of Ukraine in relation to the claims under the International Convention on the Elimination of All Forms of Racial Discrimination. 5, by 15 votes to 1, finds that it has jurisdiction on the basis of Article 22 of the International Convention on the Elimination of All Forms of Racial Discrimination to entertain the claims made by Ukraine under this convention, and that the application in relation to those claims is admissible. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado, Trinidad, Donahue, Gaia, Sebutinde, Bandari, Robinson, Crawford, Salam, Iwasawa, Judge ad hoc Pokar, against Judge ad hoc Skodnikov. I shall now call upon the registrar to read the operative part of the judgment in French. Vous avez la parole, Monsieur le greffier.
Merci, Monsieur le Président. Par ces motifs, la Cour, 1, par 13 voix contre 3, rejette l'exception préliminaire soulevée par la Fédération de Russie, selon laquelle la Cour n'a pas compétence sur la base du paragraphe 1 de l'article 24 de la Convention internationale pour la répression du financement du terrorisme. Pour M. Youssouf, président, M. Abraham Benuna, Cansado Trindade, Mme Donohue, M. Gaïa, Mme Sebutinde, M. Bandari Robinson, Crawford Salam, Iwasawa, juge, M. Pokar, juge ad hoc. Contre, Mme Shue, vice-présidente, M. Tomka, juge, M. Skotnikov, juge ad hoc. Par 13 voix contre 3, dit qu'elle a compétence sur la base du paragraphe 1 de l'article 24 de la Convention internationale pour la répression du financement du terrorisme pour connaître des demandes formulées par l'Ukraine sur le fondement de cette convention. Pour M. Youssouf, président, M. Abraham Benuna, Cansado Trindade, Mme Donohue, M. Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Salam, Iwasawa, juge, M. Pokar, juge ad hoc. Contre, Mme Shue, vice-présidente, M. Tomka, juge, M. Skotnikov, juge ad hoc. 3. Par 15 voix contre 1, rejette l'exception préliminaire soulevée par la Fédération de Russie, selon laquelle la Cour n'a pas compétence, sur la base de l'article 22 de la Convention internationale sur l'élimination de toutes les formes de discrimination raciale. Pour M. Youssouf, président, Mme Shue, vice-présidente, M. Tomka Abraham, Benuna Cansado Trindade, Mme Donohue, M. Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Salam, Iwasawa, juge, M. Pokar, juge ad hoc. Contre, M. Skotnikov, juge ad hoc. 4. À l'unanimité, rejette l'exception préliminaire d'irrecevabilité soulevée par la Fédération de Russie à l'égard de la requête de l'Ukraine en ce qu'elle a trait aux demandes formulées sur le fondement de la Convention internationale sur l'élimination de toutes les formes de discrimination raciale. 5. Par 15 voix contre 1, dit qu'elle a compétence sur la base de l'article 22 de la Convention internationale sur l'élimination de toutes les formes de discrimination raciale pour connaître des demandes formulées par l'Ukraine sur le fondement de cette convention et que la requête, en ce qu'elle a trait à ces demandes, est recevable. Pour M. Youssouf, président, Mme Shue, vice-présidente, M. Tomka, Abraham Benuna, Cansado Trindade, Mme Donohue, M. Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Salam, Iwasawa, juge, M. Pokar, juge ad hoc. Contre, M. Skotnikov, juge ad hoc. Merci, M. le Président.
I thank the registrar. Vice President Shue appends a dissenting opinion to the judgment of the court. Judges Tomka and Cansado Trinidad append separate opinions to the judgment of the court. Judges Donahue and Robinson append declarations to the judgment of the court. Judge ad hoc Pokar appends a separate opinion to the judgment of the court. Judge ad hoc Skotnikov appends a dissenting opinion to the judgment of the court. The text of the judgment is available from today in TypeScript. It will also be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.